Good morning, everyone. My name is John Benson from Penglase and Benson, where we help people get the compensation they need for their injuries. We've had a lot of requests over the time of the pandemic, over the past year, and especially this year, from people who have been injured, unfortunately, whether it be at work, or at home, or out shopping, or just driving their car. And lots of people are wondering, because of their injuries, are they able to get compensation? Are they able to be compensated for their pain and suffering from the time that they might have lost from work? People are very worried that they are going to have the money that they need when they need it to pay their bills, to pay the rent, pay the mortgage. And so we designed this webinar today to answer some of those questions so that you can quickly and easily determine if you are owed compensation for your injuries. Now, technology is very fickle sometimes, so as we're going through this, if you get a chance in the chat box, if you could please type in yes, or I can see you, or hello, or something that would just indicate to us that you're able to see everything, then we'll know that the technology is working just fine. During the period of this brief webinar that we're going to be doing today, I encourage you to have some pen and paper because we're going to go through a lot of important information. And there'll be some stuff that you'll probably want to be jotting down to have for future reference. As I've been talking, I see a number of people have indicated on the chat screen that they can see me, that they can hear okay. So looks like everything's working fine. So without further ado, I would like to jump into our presentation. So today's presentation is to determine if you've been injured in an accident, how to determine whether you may be owed compensation. As I indicated previously, there are all types of injuries, and not all injuries are going to allow you to obtain compensation for them. So if you can quickly and easily figure out what injury can possibly bring you compensation, it may give you a little bit more peace of mind, and it will help point you in the right direction and alleviate some of that confusion and anxiety. If you've been injured in an accident, and particularly if that accident was due to someone else's mistake or negligence, you may be entitled to financial compensation. During our time together today, we're going to give you a number of things. First, an overview of how to determine whether you're eligible for compensation. Next, we'll give you some insight into how you can make a stronger case for yourself should you wish to bring one before an insurance company or into court. And finally, we're going to help give you a greater understanding of what your next steps should be if you have been injured. If you're found to be eligible for compensation, the amount you gain will be based on a number of factors, such as medical bill reimbursement, replacement of lost income if you've been unable to work, as well as loss of future income. Treatment or procedures you'll need moving forward, such as physical therapy, medication, additional doctor visits. It will also be determined based on your household expenses so that we can make sure that those are covered. And that the costs associated with canceled trips or altered plans. Unfortunately, some people are unable to attend the things that they had hoped to attend. I've seen runners that were unable to run in a big race, or people that were unable to go on a vacation. So those things will be factored in to determine the amount of compensation you should get. And then certainly pain and suffering, and this includes mental as well. I have found in my experience that a lot of people who are injured, it's not just the physical injuries, it's sometimes the mental injuries. We don't always heal as fast as we think we should. And when that happens, naturally people will tend to get depressed, and that depression can start steamrolling on you. It can keep you up late at night. It can make you very depressed. It can make you avoid activities. It can change the mood that you have around the house and the way you interact with your family. And so mental is a key component here that we want to always consider when evaluating whether or not you are owed compensation and the amount of that compensation. Now, there are many different types of personal injury cases. They come in all shapes and sizes. But I want to break down what the major ones are. Those being, first, motor vehicle accidents. When a driver of any vehicle fails to act accordingly to their duty of taking care while behind the wheel, they can become liable for any damages that their negligence caused. The second type we often see are called intentional torts. This includes assault and battery, which is more considered a criminal act in many jurisdictions. In any attempt to intentionally commit violence upon another person would fall under this category. And that's a question a lot of people have, and we'll address this at the end, as we've already received a couple questions regarding it. That, just because someone was charged with a crime doesn't mean that you can't bring a personal injury action against them. Now, the third type of injuries that we often see are false arrest and false imprisonment. This type of injury occurs when a party restricts the freedom of movement of another through the use of force or threatening the use of force. Personal injury comes into play when and if there are any physical or emotional distress caused upon the innocent victim. Another type of common personal injury case that we see is medical malpractice. Medical malpractice claims arise when a medical professional can be proven to neglect their duty of treating each patient's condition to the best of their ability. Next, we have premises liability. Now, this liability comes into play when the owner of a property fails to keep the property maintained in a safe condition and a party is injured as a result. Slip and falls, non-functioning safety equipment, and hazardous conditions are all cases involving premises liability. So, for example, if there was a wet floor in a supermarket without a sign warning customers of the wet floor and someone injures themselves, they are able to bring a suit for those injuries. And the final major type of personal injury we see is product liability, and that is when a defective product causes injury or fails to display the proper warning labels. Many of you have often heard of the case of the person who was scalded by the hot coffee at McDonald's. It failed to have a proper warning label. So these are often things that we do see in product liability. Now, personal injury is a term used in civil law to help a victim collect compensation for accidents or social wrongs, including defamation of character. When it comes to statutory limitations, and this is technically the amount of time you have after an incident to file a lawsuit, each state is different. So it's very important to get in contact with a lawyer as soon as possible before it's too late. So, for example, in the Commonwealth of Pennsylvania, for most personal injury actions, you are going to have only 2 years after you have been injured to bring a claim for those injuries. If you do not bring an injury action within that 2-year time period, you will be forever prohibited from bringing a personal injury action. And the reason is courts like finality. Courts want to know at a certain point something is going to end. And so they're going to give you just 2 years to make a claim to receive compensation for your injuries. If you don't, they're going to assume it wasn't very important to you. Everyone needs to be moving on. As time goes by, evidence disappears, witnesses forget what happened, and the party that you may be wanting to sue, they're going to be prejudiced because they can't defend themselves because people have forgotten facts, evidence has gone missing. So the courts make you do something very timely, and that's 2 years. So for every state, you want to check what your statute of limitations are in that particular state. And the best way to assure that this is going to happen is as soon as you are injured, get to a personal injury attorney. Get to an attorney who is experienced, who can answer these questions, can evaluate your claim, and tell you what the appropriate statute of limitations time period is in order to file. Bodily injury is a term that is often used interchangeably with personal injury, but in fact has a completely different meaning. Bodily injury deals with a particular injury to the body of a person that is caused by someone else. The definition refers to specific injury sustained and is more commonly used in criminal cases. So in summation, a personal injury refers to any injury sustained in an accidental setting, while bodily injury implies an additional level of intent or neglect. Now that we've gotten some of the basic terminology covered, let's begin discussing what you'll need to prepare in order to file a claim and be eligible for compensation. So if you have a pen and paper, Now's the opportunity you want to take to jot down a few notes. So one of the first steps in filing a claim for compensation is to prove that the party at fault owed you a duty of care. So first step is you need to prove a duty of care. This phrase refers to the legal obligation that an individual has to adhere to a standard of reasonable care while performing any acts that could foreseeably harm others. So generally speaking, having a duty of care means being responsible for your customer's health, safety, and well-being. This could be attributed to doctors, business owners, dog owners, or any property owner. The second thing you'll need to do is to prove that the party at fault failed to adhere to that standard of reasonable care. What is reasonable care? Reasonable care is the care that a reasonably prudent person would have in going about their business or about their day. So it's a hypothetical person who usually does no wrong. That is the reasonable person. So you're going to have to prove that the party at fault failed to adhere to the standard of a reasonable care. So for example, if a restaurant is open to the public but has not secured the vents in their property, and one of those vents were to fall on a patron while dining, that restaurant would be found liable for failing to adhere to a standard of reasonable care, that being failing to ensure that their vents were properly and safely installed. So what action or lack of action did the responsible party take that resulted in your loss, injury, illness, or accident? This is something that you're going to have to prove. This means proving that the defendant was at fault for your injury. Usually this entails contextual proof that your injury was caused by no fault of your own. And this is very important because if the harm that you have suffered was due to your own fault, you're not going to be able to receive compensation. And the law is generally going to require you to be aware of your surroundings. If you see a puddle of water, you can't just walk through that puddle of water, slip and fall, and then say, oh, I've been injured. You would have to, of course, see the puddle of water and then go around it. You have a duty to protect yourself. So one of the things you're going to have to show is that you were not injured through your own fault. Therefore, you can show that but for the actions of the other party, you would not have been injured. Lastly, you're going to have to prove that you've been injured. This step entails providing proof that their negligence resulted in personal injury to you. So typically a physician's note, camera footage, or other evidence of injury will be called on to be provided. And this is very important. When you get injured, you should go to your doctor as soon as possible. And when you go to that doctor, make sure you tell the doctor absolutely everything that has happened to you since this injury, everything that you're feeling, what's not feeling good. Make sure the doctor knows that these items started hurting you after the injury occurred. Because if they happened before, then you're not going to receive compensation for those things. You're going to receive compensation for the injuries that you had, not the injuries that you had before this intervening injury. So you want to make sure that you get to the doctor, you follow all the doctor's advice, and you tell the doctor everything that has been injured due to this particular injury so that they can document it and that they can treat it. If you can prove that the party you're filing a claim against, 1, owed you a duty of care, 2, failed to meet that duty of care, 3, acted or neglected to act in a way that resulted in your injury, loss, illness, or accident, 4, you suffered damage as a direct result of their inaction or negligence, it is likely that you'll be able to win compensation. So what were those 4 things that you're going to need to show again? 1, that you're owed a duty of care. 2, that they failed to meet that duty of care. 3, that they acted or neglected to act in a way that resulted in your injury, loss, illness, or accident. And 4, that you suffered damage as a direct result of their inaction or negligence. If you've met all the requirements that we've discussed thus far, it's time to move on to the next steps. So if you have any questions, please make sure that you write the questions down at this time or in the next few slides so that we can take care of them at the end of the presentation. If you've suffered a bodily injury and someone else is clearly at fault or planned to injure you with intent, it's important that you file a police report. And you want to do that right away. The sooner you get to the police and file the report, the more serious that they're going to take it, the more realistic they're going to believe it is, and the more abilities that they're going to bring to be able to help you. If you've waited a long time, they may start to doubt your story because you've taken too long. So get to the police right away. If you've been involved in a motor vehicle accident, you want to file a claim with your insurance company right away. The sooner you have these claims on file, the more legitimate your case will be. And let me emphasize with a motor vehicle accident, if you've been involved in a motor vehicle accident, it is very important to call the police right away. Why? Number one, they're going to come and they're going to be able to provide you any help that they can. Number two, they can arrange to get medical care for you immediately. But most importantly, number three, they're going to come and they're going to document the accident scene, where the cars wound up. They'll be able to determine where the cars sometimes made contact with each other. They're going to be able to take scene pictures and measurements. All of these things are going to be critical in being able to prove that it was another party that caused the injury to you and not you causing the accident. So make sure you contact the police right away. When it comes to filing a claim with insurance, there are two types: first party and third party. So jot that down. You have two types of claims: first party and third party claims. A first party claim is the claim you file with your own insurance company. A third party claim is one you file with the insurance provided by another person or their business. The type of claim you file will be dependent on who was at fault. So for example, if you caused a car accident while driving, you would file a first party claim. However, if you were hit by a car, you should file a third party claim with the driver's auto insurance provider. Alternatively, if you were injured while shopping at a store or eating in a restaurant, you would file a third party claim to the business insurance company. So if you've caused the accident, then you should be filing a claim with your own insurance. If someone else has caused the accident, then you should be going through their insurance. From doctor's notes to medical bills, time taken from work to communication between you and the defendant, every record you have can help you in court. So you want to make sure that you document everything, that you document when you go to see a doctor and what doctor you went to see, that you jot down all the different times and the amount of time it took to go to the doctor's office and come back. You want to keep all of your medical bills. You want to keep every receipt that you have for any money that you've spent to take care of your injury. So if you go and buy a bottle of aspirin, if you get an ice pack, you want to save those receipts because that is money that you can be entitled to be compensated for by the insurance company at a later point. But if you don't save the receipts, they're not going to compensate you. So you want to document everything. In order to learn more about information you should be recording and to ensure that you don't leave out any important information, make sure to check in with us at the end of this presentation, and I'll give you a list of some of the things that you should be jotting down. Was anyone else there when the incident took place? Getting witness statements can strengthen your case immeasurably. The more witness statements you can get, the better, because then it won't just be biased. It won't just be, oh, this happened to me, or you had a friend in the car who might be having a financial interest in seeing you do well. If you have independent witnesses, the more witnesses, the better. So make sure you get their information and their statements. Getting witness statements can strengthen your case. Once you get in touch with a legal representative, gather affidavits and firsthand accounts to back up your story and perspective of what took place. You want to be as detailed and as clear as possible. Be careful with your wording and double check every account before you turn it in to ensure that it helps your case and doesn't harm it. Very, very important. Before you turn any witness statement in, make sure you reviewed it, because if it puts any type of blame on you, it's certainly not going to help your case. After sustaining your injury, keep a journal to record any pain or other symptoms you're experiencing and update it daily, making sure to timestamp each entry. The record will also strengthen your case. So if you failed to sleep because you couldn't find a comfortable position, and the next day you're really grumpy, or you're irritable, or you're constantly falling asleep at work, you need to jot those things down. Why? Maybe a year from now, you could be sitting at a deposition table, or you could be in court itself, and someone's going to ask you, well, gee, how are you feeling back then? And you're just going to lump everything into this dark period of your life, and you're going to say, I felt bad. And that's going to give you one form of compensation. But if you can come in and state, well, on this date, I couldn't sleep very well because I couldn't find any comfortable position, so I was up all night. The next day I was very irritable, and then I started falling asleep, and everyone was getting mad at me at work, and that was making me depressed. That's going to give you a lot more compensation because you're able to relate these fine points. So you want to make sure that you've documented everything that's happening to you in a journal so that you'll remember it for later on. Clear and concise documentation is critical in building your case and sharing your experience of how an incident played out. When in doubt, record it. Whether it's a receipt from the gas you spent driving to and from medical specialists, to the text conversation you had with a friend describing the incident after the event. The more information you bring to the table, the clearer you can tell your story. The best thing you can do to protect yourself and gain the compensation you deserve is to work with a legal representative who you can trust. Even the most studied person cannot fully comprehend the nuances of the legal system without experience. Additionally, a legal representative can give you a better understanding of what you're up against when it comes to providing context, history, and precedent. We know that this process can feel extremely daunting, especially with all the legal jargon you may be facing for the first time in your life. Our final tip we want to share with you is that it is crucial for you to remain as calm as possible and trust that you will get the help you need to parse through the complexities of this process. That's what our team is here for. That ends our presentation today. I'm going to be giving you some tips in a few minutes on some things that you want to make sure that you record all the time, and answer a couple of the questions that came in during the presentation and beforehand. But I want to emphasize, if you ever need help regarding this, if you ever have any questions about the information that we've gone over, you want to run a scenario by, or you've either been injured yourself or know someone that has, please contact us at this address that we have listed here. At Penglase and Benson, the number is 215-348-4416. You can find us on the web at penglaseandbenson.com. You can also email me at the letter J, Benson at Penglase, the word and, Benson.com. And you can certainly always find us on Facebook, Twitter, Instagram, and our YouTube channel, where we have a number of videos that may help you with any legal problems that you have. So everyone, as I told you during the presentation, there are certain things that you want to be very careful that you make sure that you record. So if you have that pad of paper, here's some things that you want to jot down. So the things that you should be recording. First of all, the identity of any of the parties involved in your injury. And by identity, you want to get down their proper spelling of their name, their full name. You want to get their address. You want to get their phone number. Do that right at the scene, because they're going to disappear and it's going to be very difficult to find them. So you have to get that information. So if you've been injured at a store, you want to make sure you get the name of the store, the date, the time that you were injured. If you were injured at a store, you want to make sure that you bring it to the manager's attention or someone else who's of authority there in the store immediately. Make sure that you get their name, what their position at the store is. Jot down what time that you reported this to them and answer any questions that they have. If you can get the store phone number, that's going to be helpful as well. Again, number two, any witnesses. Make sure that you go around. Anyone who possibly saw this, you want to get their name, their address, their phone number, and a statement from them. If you can get them to write out a statement while they're there, that would be fantastic. If not, make sure that you take good notes and then you get this information to your legal representative as soon as possible so that they can follow up and properly document their statements. If you have a camera, Most people have one on their cell phone. If you have a camera with you, certainly take as many pictures of the scene as you possibly can. You never know what angle or what picture is going to show some critical data. One time we had a case, and the individual took a lot of pictures of the scene, but the big question was going to be, where exactly on the roadway did the cars collide at? So that we could tell, number one, who was at fault, and we could also determine the speed of the vehicles. Well, fortunately, they happened to take one picture out of 100 that actually showed grooves in the roadway where we can actually see where the two cars collided. And no one was really paying attention, but through the picture, we were able to see this a couple of days later when it was brought to when the case was brought to us. So you never know what picture is going to give you some information. So take as many pictures as possible from as many different angles as possible. Also take pictures of your injuries. They're going to change over time. Bruising changes on a daily basis. So you want to make sure that you take a picture of your injuries. And if you have a ruler, put the ruler next to the injury so we can see exactly how big the injury is. Because if you just have a bruise on your arm and you take a picture of that, we can't tell, is it 1 inch? Is it 5 inches? There's no way to tell. So make sure you have a ruler next to you so that we can get some sizing for that. And the final thing that you want to certainly jot down is all receipts. If you spend any money for any of your injuries, whether it's for a copay or for an exam, you want to make sure that you jot that down. You keep those receipts so that we can seek compensation to get those things reimbursed to you later on. Now, I indicated we had one question that came in before we even did the webinar today. We had one that came up during the webinar, so I want to address them. The one that we had was, do criminal charges prevent me from filing a civil suit? The answer is no. Civil and criminal are two different worlds, and they can handle things in different ways. If I'm to bring a personal injury action, I can get you compensation and money for your pain and suffering and your injuries, but I can't put someone in jail. If a person has hurt you criminally, whether it's an auto accident and they were driving under the influence or assault and battery, a criminal case can put someone in jail and make someone pay restitution, be on probation, be monitored, but they can't get you compensation for your injuries or pain and suffering. So they act in two different realms. So if someone has been charged criminally for injuring you, they can be sued civilly. But when you go see your legal representative, make sure that you make them aware of those criminal charges so the two sides aren't stepping on each other's toes. So the answer is yes, you can bring a civil action even if a criminal action has been brought. This is certainly in the Commonwealth of Pennsylvania. Check your jurisdiction. The other question that we had was, should I give a recorded statement to the insurance company? Well, yes and no. If your insurance company, the insurance company that is insuring you, if they are requiring a recorded statement, you certainly want to help your insurance company out because they are there to help you. And by not giving them a recorded statement, it may hold up the amount of compensation they're going to be able to bring to the table because they don't have all the boxes checked off that they need to have checked off. But again, before you make any statement, check with your legal representative. But usually it's not bad to give a statement to your insurance company. How about the other insurance company, the insurance company for the store where you were injured, or the insurance company that represented the gentleman or a lady who injured you who was driving under the influence? Those you don't want to get. And make sure, again, you make the legal representative aware as soon as possible that that insurance company has called you and that they want a statement. Why do they want a statement? They're not trying, they're going to tell you, hey, we need a statement so that we can check all of our list off and we can give you a check. What they're trying to do is they're trying to get you to give that statement. Most of our clients are going to get compensated. They never make a recorded statement with the other person's insurance company. Why is giving this statement so important and that you want to avoid it? Because they're going to record it. And if you have to file suit one of these days, you're probably going to get deposed. And when you get deposed, you're going to give a statement under oath that's going to be recorded. And now this is the second time you've told the story. You've probably also told the story to the police officer. And when you get to court, you're going to get up on the witness stand and you're going to tell the story again. If your story changes even a little in any of those four statements, they're going to call you a liar. And that's what the conversation is now going to be, is that you were a liar. And folks, if you tell any story, Goldilocks and Three Bears, it doesn't matter the story. If you tell any story enough times, sooner or later, you're going to change one or two of the words. So the more that we can limit the amount of recorded statements that are out there, the more you can be helped should you need to file a suit. So again, if the other insurance company wants you to give a recorded statement, politely decline, speak to your legal representative, and only give that statement after the legal representative has determined that it is in your best interest to do so. That is all the questions that we have at this time that have come on in. Again, if you have any questions later on after you've watched this, you can certainly contact us. My name is John Benson. You can reach me at 215-348-4416. You can also email me at the letter J, Benson@Penglase-Benson.com. You can find us on the web at Penglase-Benson.com, and certainly you can find us on Facebook, Twitter, Instagram, and certainly check out our YouTube channels. Thank you everyone for attending our webinar today on how to determine if you are owed compensation for your injuries. I hope this has been helpful for you, and I look forward to speaking to you at some time in the future. Have a good day.